I just want to put this out because probate's really difficult. It's like tax law, it's like immigration law. There's a lot of deadlines that you have to have, and we're not very yielding when we come to those deadlines. And so if you're representing somebody that either brings a will or makes an application for a determination of heirship, which would be required if there were monies to be had and dispersed among the family, you're going to appear before one of the probate courts. Now, when I say it's very difficult, they are time specific. What I'm handing you is a compliance list that we give to each and every applicant. They are to produce those documents within that time frame. You get one extension and only one extension. And if you don't, what happens is if you're representing the applicant, aka the executor or the administrator, if those documents are produced by the timeline that is given statutorily, then they're removed. And then we have to put somebody else in their place. Now, on top of that, other than those dynamics, you've got to be able to ascertain whether the will, assuming there's a will, that the will is valid. If it's an heirship, you've got to be really good with fractions. Because if you don't get the fractions, it's going to be bad. Because we look at those fractions, and I know Ms. Stribling, Mr. Falvey, Ms. Coulter, when we start getting into 1/152nd of the family as it goes down, if there's anybody that's predeceased and that type of thing, those numbers are going to impact everything. And if your client's expecting to get 1/5 or 1/5, and all of a sudden it's now nowhere near that. So think about that. If you haven't done one and you're intent on doing it, I'll give you a list of the probate bar. They do it all the time, and they can kind of guide you there. It's a very collegial group. They will help you out, but it's imperative that you understand what the dynamics are. Now, like I said, you have the probate. That's assuming that there's a will, and whether it's a valid will, whether it's a copy of a will, whether it's a holographic will, there are different standards for each type. If it's an heirship, is somebody predeceased or are they still surviving, that mandates whether community passes to the spouse, whether it stays or it's divided among the children. If there's no children, if it's going to come back up and go to the parents or the siblings. And so you have to really understand your heirs at law when we start dealing with all of those things. The other thing that you're going to be looking at, if it's transferring from the spouse to the other spouse, whether it would qualify for what they call a small estate. Only El Paso County and Hidalgo County do small estates. It's in the probate code, but because it has a tendency to allow for a lot of fraud, most counties will not allow them. And when we say just from one spouse to the other, what we do in a small estate, especially by nature of our community and its degree of poverty, will we allow them, but it's from the spouse to the spouse. We don't do it for children, we don't do it for aunts and uncles, nothing. It's spouse to spouse. And it's to control the tendency for fraud. So if you're transferring, what we're talking about is you've got a house, one dies, then we transfer the other half, their community half, to the spouse. Because under an heirship, that individual would be entitled to 100% of the community estate anyway. And so it's a way to save your client money. In this case, the county has already graciously will absorb all of the costs. Now, one of the reasons you're here, you get free CLE, but you have to volunteer. Tell me if I misspeak, but the probate bar has agreed to represent any individual that needs one of these absolutely free. The county is absorbing all of the expenses, filing fees, expenses of any representation, that type of thing. Okay, so filing fees, fees for letters, that type of thing the county is picking up. What you will need to do is file a certificate of indigency, okay, on all the cases. In that certificate, you need to file something in the blurb in there that it's from the Walmart sheet. And that is how the county is going to ascertain what pool of money they're pulling from, okay? That little blurb also will be in the order, okay? Yes, sir?
Small estates, is that under 75,000?
Yes. It's usually just a home, usually.
Okay.
Okay. If they have a will, though, you have to go with the will.
Right.
Okay. No will, it's going to be an heirship. Okay. Now, like I said, you've got the small estates. Then we come to, and that's just on decedents. Then you've got the individuals that are injured, and so you have to ascertain. I know we have a couple there that are still in serious condition. We're not aware of their injury, so we don't know if there's a traumatic brain injury, if we're going to need a guardianship over them, or a guardianship over their estate as we progress through here. And I assume most everybody got guardianship in law school, so I won't go into the details of that. But along with that, and depending on the circumstances of the case, we may be talking a management trust or a trust. I mean, it just starts kind of blossoming out of what has to be done in a particular case. And each one is case by case. So that's where we start running into the really complicated stuff and the taxing implications and so forth. I will hand you a list. Did I bring it up here? Oh. This is an old list of the probate bar, but it'll work. So if you decide you're going to do it and need help, call a member of the probate bar. I'm sure they'll be glad to kind of walk you through it. If you decide not to, you can always refer the individual to a probate attorney. And you know, I can tell you, like Ms. Stribling's like the expert on trusts. We've got some, Ms. Coulter is the expert at Social Security and Medicare and Medicaid. We have some with particular expertise. Mr. Falvey back there is a real estate man. And so on top of the probate, he also understands the implications of having real property and what needs to be done with that individual, with that particular asset. So you have those elements going in. We've got the disability, which is the guardianship. Now, just so you all know, I know there were some children involved. We normally do not do guardianships over children because there's a less restrictive alternative, which is the conservatorship in family court. The only time we will do a guardianship over a minor is if there's an estate. And if there's an estate, then we have to open one up, okay? And just so you know, depending on the amount, we will usually appoint a bank to be the trustee, okay? Sometimes it's the parent, but only if it's a small amount. If it's under $25,000, we might appoint the parent. If it's over $25,000, if you're talking $100,000, $200,000, a bank is going to be appointed automatically, okay? Just so you know. We usually don't, and I'll give you kind of an idea. We have had in my short time as a judge where there was a lawsuit, the family got a great settlement, they weren't the injured party. They immediately paid off their house, they bought a car for each of their kids, and now we've said, you have to get rid of all those cars and put money back in to the estate of the individual because that money wasn't yours to spend. And now we've got receivers in place and the court has had to intervene because they abused the money. It was a great deal. You know, they got their house paid off, which we can't do much about, but they're now doing payments to the estate. Okay? Let's see, what else did I have? If there are powers of attorney, hopefully they were executed before any tragedy happened. If it's an individual that had capacity, you can do a power of attorney, those are great. If it's an individual that has significant trauma and is not able to sign, if they don't have capacity, that may be a problem. That's usually a contention point in there. Do you have any questions? I'm going to give you because you either got it or you don't, so I'm sorry. So, does anybody have any questions on probates, guardianships? Yes, sir.
So on the small estate affidavit, you said it's only from one spouse to the other?
We control it only, and Hidalgo does the same thing. Because we are the only 2 counties in the state of Texas, because it's ripe for fraud. You can say, and I'll give you an example. We've had somebody come in and say, hey, you know, this is my aunt, she gave me this property. Luckily, you know, my auditor looked it up. She goes, this property's already been transferred out. It was transferred out 5 years ago, you know, to the niece. Way before her death or her incapacity. But that's the kind of thing that happens. You know, somebody will say, oh yeah, I'm the only child, and then we find out there's 5 others. You know, so that's why we decided, you know, there's no mistaking, spouse to spouse, this community, she'd be entitled to the community property anyway, under an heirship. It's a very inexpensive way, and finally, it's not particularly cheap, but it's a very inexpensive way to transfer title to a property that would be that individual's property anyway, under an heirship.
What if it's one parent, no spouse or divorced spouse, and several kids?
You're going to go through an heirship. Yeah. Spouse to spouse. Yes?
Because those are the only 2 counties that do it, do you do it for the other counties that
No,
don't do it?
we don't take anything out of our jurisdiction. Yeah. They make them go through either a full-blown probate or a full-blown heirship. So,
If it's just real estate, then sometimes they can do an heirship affidavit, right?
sometimes. But there's little nuances, and that's why you really need a probate attorney that comes in, because they actually, what's that statute on?
What's the time frame for determination of ownership?
Well,
And are emergency orders available?
no, there's never emergency orders available, except for guardianship. We'll do a temporary guardianship that is under an emergency situation, but never a probate and never an heirship on an emergency. Now, we'll give you, because there's statutory timelines that we have to follow, so it's real hard to get, you know, in, you can't file it and then have a hearing the next day. So, you know, it's got to have notice, it's got to have, you've got to allow it to sit out there for a little while in case somebody contests, and that type of thing. Okay? Any other questions? Okay, very good.
Joining us.
Thank you.